I am Anastasia Cowan. I work for the law firm of Arnold and Smith. It's in Charlotte, North Carolina. I worked previously for an organization called the Council for Children's Rights, where I represented children in mental health proceedings and in delinquency proceedings. I transitioned to Arnold and Smith about 3 years ago, and I'm now doing a really great mix of juvenile work as well as family law work. And so in doing that, I realized what an immense overlap there is, and the problems that come with that immense overlap and the solutions that we can try and find to that overlap. So that's a little bit about my background, and I have never done a PowerPoint presentation before. I made it through high school and undergrad and law school and life up to this point, and this is my very first PowerPoint presentation. So it's pretty lame. It's all black and white because I don't have the capability to do any of the cool stuff, but maybe next time. So bear with me. I also am really bad at sitting still, so that's why I am over here as opposed to over there where my name is. So I'll probably move around a lot if you need to remind me to take the microphone because you can't hear me. I'm pretty loud anyways, but just remind me. So I have learned through my representation of children and working with children in general that positive reinforcement works, and so I brought candy. So if you participate, you get candy because this is supposed to be really interactive. What I have case studies of a lot of cases, or taken from a lot of cases that I've worked on, and I want to share with you how I have managed some of those, and I want to hear from you about some of the problems that you see even with the way that I have managed some of those, and what solutions you have found. So it needs to be interactive. I contacted a colleague. I was like, this is my first PowerPoint presentation, so I'm speaking for an hour and a half. How many slides should I go on for an hour and a half? And she very, very, very confidently said 15. That means you have 5 minutes per slide, and then you have a 15-minute buffer for conversations and questions, etc. And I don't think like that, so that's why I asked her. I asked my husband the same question, and he is in the medical field. He's a pharmacist, so he's very linear and he's very math and science oriented. He said 60. So somewhere between 15 and 60, you have 30. So you need to participate, and hence the candy. So to get started, I just kind of wanted to talk about, so when I started, I was really only doing child welfare and delinquency stuff. And so when we are doing those child welfare proceedings and we are in that network, and I think you all understand what I mean when I say in that network. So we engage so many people, it's holistic representation. That's what we build our life around. We build our life around holistic representation and meeting children where they need to be met, and finding services for them, and engaging people, engaging resources, engaging family members, engaging interdisciplinary practices, social workers, education providers, mental health providers, etc. But yet at the same time, in our quest for having this great holistic representation, we are such a small, closed community, and we only really, at least in my practice and where I was coming from, we were only really functioning within our own child welfare kind of community. And so we were utilizing the resources that we knew of that were available. But the main thing that I saw when I was representing children was that they are participating in a lot of different communities. So it's not just the child welfare community. So the exact same children that I was representing in delinquency court were the same kids that I was representing because they were in residential treatment facilities a week prior, or they were in an acute hospital a week prior, and were the same kids that you see in abuse, neglect, dependency court on Wednesdays where I practice. And so they were all the same, and they also were dealing with family custody issues. And so we could deal with the child welfare, abuse, neglect, dependency cases. We could deal with the delinquency cases, and we could deal with those mental health cases as well. But we really were not actively engaged in the family law part of it. And it was in that family conflict was driving a lot of what was happening in all of those other things. So if you're talking about domestic violence, you're talking about substance abuse, you're talking about child abuse, you're talking about neglect, you're talking about any of these things, it's coming from that family dynamic, generally speaking. And so if you are also involved in the family court system, how can you not be engaging with that system? And that is the disconnect that I never saw when I was only practicing in the child welfare realm. And so now that I'm doing a really good mix of both things, I see it every day, and I see it in every single circumstance. And so, switching gears, custody attorneys. We are even more of a closed group than child welfare. We do not engage with anyone unless we have hired them as an expert of some kind, or we have subpoenaed them to come to court with all of their records, i.e. teachers or medical providers, etc., or whomever. We're not engaged in all of the inner workings that we are in the child welfare realm. We're just not. That's not how we function. We can get people to come under a subpoena, and we can, but no one wants to talk to the terrible divorce attorney, let's be honest. And we have that reputation for a reason. And whenever I first started at my current firm, my boss jokingly called me a true believer, and he, which I thought was a compliment. And I was hoping to be able to take that into the big bad world of custody as well. And that's what I try to do. I try to create more holistic representation because of my background in child welfare. And so, but the problems that I'm seeing is that because there are two communities that never intersect, we don't speak the same language. And we don't know the inner workings of the other community. And we don't know how the processes work. And we don't know what you're allowed to do in this court setting and what you're not allowed to do in that court setting. And we don't know how, in particular, how social workers are used in each set of places. And so that is kind of the theme of what I wanted to talk about today, and a lot of what my case studies are about. And again, bits and pieces of these cases are cases that I have dealt with just this year. So here, and hopefully you will catch these references. I have shown this to my husband, I've shown this to coworkers, etc. Ross and Monica, anybody? Anybody for the first piece of candy? Yay, he said it. I'm going to throw it. My aim is not very good. So, mom and dad were never married, and they're not together. They have two children, Ross, who is 14, and Monica, who's 10. Dad has never, ever really been around much and lives in California. Mom lives in North Carolina. Mom is heavily involved in drugs, and dad learns through a neighbor that there have been numerous drug raids on the house, and that meth is found. Is this a custody issue, a DSS issue, or both? So who thinks it's a custody issue? Most people say it's both. And so it started out, when I was presented with a similar issue, I started out as a custody issue. So there was an order in place that gave dad really not a whole lot of visitation, presumably because it was an out-of-state order. But so he filed for emergency custody. And in North Carolina, the statute for emergency custody is that you have to show that there is an imminent risk of substantial bodily harm to the children or sexual abuse, or that they're going to flee the jurisdiction. So we filed for emergency custody. So we go, and dad gets emergency custody. They put it on for review right away. We generally do that within 10 days. And so we go back for the review, and mom is present. She's represented by counsel, and all of a sudden, mom says, well, dad sexually abused Monica when she was 2, and he can't have emergency custody. So what's going to happen? There's no record of any of this sexual abuse. The police were never called, DSS was never called, and there was no therapy for Monica that anyone knew about. When questioned, mom said no, that never took place. Is it a DSS case? Is it a custody case, or is it both at this point? Yeah.
I'm from Utah, so in Utah, if you're going to use an allegation of abuse or neglect, you have to report it to DCFS.
Okay.
So if you come to court and make that allegation just out of left field, the first question you're going to get is, well, has DCFS received a referral? So if you haven't made that referral, so from my perspective, it would be both, because dad in this emergency jurisdiction request would probably have been required to report it to DCFS, and the court would not give mom any credibility if she hadn't done the same.
Perfect. So here's your candy. I'm going to throw it. Awesome catch. Much better than my throw. So, the judge decided the same thing. And in North Carolina, we also are, everyone is a mandatory reporter. And we're going to get to that later when I talk about some of the ethical considerations of that and how we use that, etc. But the judge in that case decided that, okay, the judge made a call to DSS, and DSS became involved at that point. The custody case was stayed, and an entire juvenile proceeding happened at that point. What ultimately happened in that case is that Dad did, the children were adjudicated that they were dependent, and Dad followed a case plan. Dad followed, he did everything that was required of him. He had to do a sex abuser evaluation. He had to take parenting classes. He had to do, there were allegations that there were domestic violence 10 years in the past, so he took DV classes. He did random drug screens, everything, and the kids were never returned to his care. The kids had been so severely alienated from Dad that they went in chambers. I went in chambers, made question. The judge saw the alienation, but because it was so bad and they just wanted to be done after a year mark, they granted guardianship to Grandma, who Mom, of course, lives with now. So that's what happened there, and that's kind of one of the reasons why there are these conflicts. Because I believe that if this were just a family court case, that some of these would have been avoided. We have a lot of resources. There are lots of resources that are available in each of the separate jurisdictions, but they don't necessarily overlap. So if I had been able to do this in a family court setting, we would have gotten a private guardian ad litem involved. We would have been engaging specific therapists who were not just the therapists that were contracted with DSS to treat children, but people who were actually really, really specifically dedicated and trained to dealing with these alienation issues. And we could have been asking for reunification therapy and doing these sorts of things that we were able to do in some respect in the abuse and neglect dependency court, but it kind of fell on deaf ears that in a custody case, if you had filed these separate motions and you had been able to provide these service providers, and my guy could pay for it, he could pay for it, then you probably would have gotten it in that realm. But because there is you had guardian ad litems and you had social workers saying, well, these kids, they're just terrified of Dad. They're just terrified of Dad. Okay, well then we're not going to make the kids do this. But in family court, I wholeheartedly believe that some of that situation would have been different. So here's another one. Mom and Dad have a custody order whereby they share custody of their 10-year-old daughter Phoebe on a week-on, week-off schedule. Dad learns that Mom is dating a man, Chandler, who has been charged with indecent liberties of a minor, a 13-year-old girl, and all of a sudden Phoebe begins exhibiting sexualized behaviors when confronted about these behaviors, Phoebe says that she learned about these things from Chandler. Custody case, DSS report, both, first of all. Both. So are there any social workers in the room? Okay, 2, perfect. So if you were to get a call from a parent who says, I'm going to put you on the spot, I apologize. You are getting a call from a parent who is making this report. What's the first step for you as a social worker?
Gather information.
Okay. So who are you talking to?
The child, the parents, the boyfriend, the dad.
And so if the child were to disclose this to you as well, that she learned these behaviors from Chandler, whether or not she had been inappropriately touched, whether or not she had seen inappropriate material, whatever, what would be the next step for a social worker in this setting?
If it meets criteria for abuse, then it would be a CPS investigation.
So, in this case, very similar situation. Again, represented Dad, filed for emergency custody. Dad did make a CPS report, and the social worker was called to testify in in the custody case. And so all throughout this case, this has remained there was a CPS report made and an investigation was made, and then there were recommendations for a safety plan and a voluntary placement with Dad until things were figured out more. But then it was closed out, and it remained in family court for the remainder of this case, which has been ongoing for 4 years at this point, and we have a trial in a month. So finally. But that's how this all played out. And so that is one of the things that we'll talk about later, is how if something starts out as a CPS report and then also becomes a family court case, how do you use that information that was reported to DSS, is what we call them. So that is something that we will touch upon later. And I really am interested in hearing how people do that in other places, because I know how we do it, and it varies from county to county, really, how that works. I work in a variety of counties, and so the main county that I work from is Mecklenburg County, where it's Charlotte. But I also work in all of the surrounding counties, and I've really been to pretty much almost all of the courts in North Carolina. And so and it just varies completely how this information is used, what's allowed in, how we treat social worker testimony in DSS cases, how we treat social worker testimony in custody cases, how you use CPS records, how you get CPS records, can you get CPS records, all of those things vary so much from county to county, courtroom to courtroom, even within the same county. And so I'm very, very, very interested to hear how people are dealing with that.
In Anne Arundel County in Maryland, we devised a what we call a triage program. So when there are allegations of abuse or neglect of one parent or another, we have in-home custody evaluators who are social workers. So they're a link to DSS. They make a DSS report. And we have formal court orders that order DSS to provide us with the records that we need in court.
Perfect.
I guess my question is DSS, what does that mean?
Department of Social Services. So that is another thing that varies from county to county.
State to state, because I'm assuming that was CPS, because we don't call it.
Yes, it's CPS, Child Protective Services, Youth and Family Services is what we call it in
Texas
Charlotte.
Is Department of Family and Protective Services. That's why I was like.
Yeah, so I'm gonna I think the main one that we use in North Carolina is DSS, and so that's generally, when I say DSS, that's what I mean. Thank you I meant to clarify that. Yes, it's everywhere from county to county, state to state, etc.
I guess I'm spoiled with my county because we have a designated court. One court, one judge, hearing all cases involving Department of Family and Protective Services. So it's pretty much the same judges hearing the cases to maintain continuity, no transferring of jurisdiction, to another district judge or county court.
So I'm glad that you brought that up. Mecklenburg County is one of the only counties that in North Carolina that has a designated juvenile bench. And so we have, I believe it's 6 juvenile judges, and they handle all of the juvenile cases. So if you have an abuse, neglect, dependency case, then that's going to be your judge if you get delinquency charges. And that's going to be your judge if all the juvenile judges do the mental health commitment hearings as well. And so we do have that continuity with respect to within the juvenile realm. However, family court has its own designated bench. And so family court, again, separate entities. So you're not getting that same continuity that you would get in your jurisdiction, because it is not the same. I am incredibly happy that our juvenile bench is so well versed in juvenile law, because it really is a different animal, and that our family law bench is so well versed in family law, because it really is a different animal. But you have to be aware of these things that cross over, and they're just not. When I am in family court, it is mind-boggling to me the things that the judges don't know the procedure for A&D court, abuse, neglect, dependency. They don't know the process. They don't know whether a family has been involved unless it's in the pleadings and they've gotten the records, etc. They don't have any of that information. So I owe people candy.
Thank you.
I owe you candy. And I owe you candy way back. I'm going to try really hard. And I so, if someone can pass it back. This is a case that I have seen a lot of, actually. So DSS gets a call from the police roadside. A man has been pulled over for driving while impaired. His 6-year-old Joey is in the back seat. Dad tells DSS to call his parents to retrieve Joey. Joey goes with the grandparents. DSS comes back out to the home the next day to meet with Dad. Dad had tested positive for cocaine, and DSS doesn't feel comfortable with Dad having Joey unsupervised until he does a substance abuse assessment, submits to drug screens, etc. DSS and Dad enter into a safety plan where Joey is going to live with grandparents through a voluntary placement, and Dad's going to complete all of these things. And then if he does everything and he completes all of the things that they want, then they'll close out in 45 days. However, there's a custody order that gives Mom every other weekend, and Mom was never notified of any of these safety plans that were going on that places the child with the grandparents and all of these things. So is this a DSS case? Is this a custody case? Or is this both? And is that okay that, that Mom was not made aware that this was happening?
Does she have joint custody in her order?
They have joint custody, she should have been given custody.
So I see this happening a lot, and these voluntary placements that don't involve like a petition being filed, and so there's no judicial oversight to it, and there's generally speaking, when there's a primary custodian, and this is what's happening, these voluntary placements happen, and the idea, I think, I don't know, but the idea, I guess, is that, well, Mom can still get her every other weekend, because just because he's with grandparents doesn't mean that the custody order can't be satisfied, and Mom still can't get every other weekend. She totally can. Grandparents are going to let her have every other weekend. So that's a situation that I'm seeing a whole lot of. In a different light, I see the same like sort of factual scenario happening where there's not a custody order, and then a petition is filed, but there's never anything wrong, or no one makes any allegations against Mom. So why was there a petition filed? Why does this not just become a situation where there's a voluntary placement with Mom until these things get settled, or Mom files for custody, maybe she doesn't know she can. All of these things, I'm seeing this factual scenario played out a lot in various different tweaks to this factual scenario and what happens.
And there's an assumption that Mom actually gets along with the grandparents.
Right.
I've been in situations where she can't stand the grandparents, and they're the parents of the father of the child.
Right.
They don't get along.
Right.
So that's why it's prudent to give the opposing spouse notice, or the other parent notice, because there may not be an amicable relationship with the grandparents.
So in this exact same factual pattern, we filed to modify the custody order, filed for emergency custody, and the grandparents actually intervened and tried to intervene as parties to that modification and succeeded in that. So in the factual scenario that I spoke of before, very interesting. This is not my case. I was just sitting in the courtroom actually when I saw this happen. And I'm watching and I'm watching and I'm watching, and the factual scenario was the one I said where there wasn't a custody order in place. And so Dad had been pulled over with drugs in his system, etc. They placed with a grandparent, I believe, and Mom was never made aware of it. But there were never any allegations against Mom. Mom had an every other weekend schedule. I don't know what why. Again, there wasn't an order in place, but that was just kind of the way they had done things. But she worked a job. There were no allegations that she had any sort of mental health issues, nothing. And so I was sitting watching, and there was an adjudication, and the child was found to be neglected, and you're going through this whole proceeding, and in my opinion, there didn't need to be a whole juvenile child welfare case open. That's a waste of resources. That is a waste of really valuable resources. There are a lot of kids that need that kind of intervention, and because caseloads are so full, they're not getting that kind of intervention. And here we have a place where it's a custody issue. Like, mom can take custody of this child, and they can do whatever they need to do to work out whatever the arrangement is going to be when dad takes care of whatever's going on with him. So that was a situation that I saw.
What was the court's reasoning in giving the grandparents custody?
In the case where there was an order in place, they just intervened. They didn't. They were able to intervene to fight for custody.
Oh, okay. They didn't actually get custody.
Right.
Okay.
So, here's your chocolate.
Oh. I didn't know I got candy.
You get candy.
Because I was
participation is key. Positive reinforcement, aka bribery, whatever works. Some of the problems with the overlap, some of these that we've already talked about, we all know, and I think this is part of why the custody section gets a bad rap partially, is the overuse of inappropriate DSS calls in custody cases by people who are trying to further their case. So I think that you also can put into, and we'll get to this with the evidentiary issues as well, but you probably can put into that kind of funneling evidence through DSS reports, and we'll talk about, I'm guilty of that. I've done that. I have funneled evidence through DSS reports, because how the heck else are you going to get it in? It doesn't fit into a child hearsay exception, and that's the only evidence you got. So we'll talk about that in a little bit more detail under the evidentiary issues. But social workers being subpoenaed to court in custody cases, they hate it from my experience. They fight it tooth and nail. They do everything they can to avoid it, which I get. They are overworked and underappreciated. They have huge case laws. They have huge caseloads that they can't, I don't know how they manage them. And then they're being called over somewhere else to do something else. I understand. And I respect greatly what they do, and the position that when I'm in that situation I put them in by taking them away from those other cases and putting them into this jurisdiction. But again, we are all working under the best interest of the child standard. So family court and child welfare court, it's the same, best interest of the child. And so how do we get there? And how are we managing these types of problems? So domestic attorneys not knowing what's required when DSS is involved with one of their clients, and they come a knock-in and they're saying do X, Y, and Z, or we'll file a petition, etc. Domestic attorneys are like, oh, you don't have to do that. They didn't do anything. They don't have any authority. Oh no, they do what they're asking you to do, and they'll get out of your life. And that is a problem, because again, we don't have that overlapping knowledge. DSS, for whatever reason, doesn't always know that there is a pending custody case, or that there is a custody order in place that provides for who has what time, etc., who gets to make legal decisions for the children with respect to where they're going to school and medical decisions and whatnot. So if DSS gets a call that says that mom is either not taking a kid to the doctor and he has these chronic needs that aren't being addressed, or that mom is exhibiting Munchausen's by proxy, which I had a really terrible case about, and is taking the kid to the doctor for everything under the sun. But what you don't know is that mom is the only one with legal custody, and that could be a custody issue. That could be a custody issue, that you can change legal custody and give decision-making authority on with dad to those medical decisions if that's what's happening. And it doesn't necessarily mean that it has to be a change in physical custody if that's not what's best for the child. But I have seen a lot of DSS calls and get a lot of cases where it is that medical neglect of some respect, but really, if there's a custody order in place, that can be resolved. There can be measures put in place under a custody order that provides that dad gets to make these decisions. Dad gets to decide who the doctor